number 57, the people of the state of New York versus Ron Hill. Counsel, just give your colleagues a moment.
Yes.
Good afternoon, counsel.
Good afternoon, Your Honors. Harold Ferguson for Appellant Ron Hill. We would request 2 minutes for rebuttal in this case.
You may have 2 minutes, sir.
Your Honor, not all synthetic cannabinoids are illegal in this state. Only those specifically enumerated in Public Health Law 3306G are the ones that are illegal. Here, the complaint is jurisdictionally defective because it did not allege that my client possessed an illegal synthetic cannabinoid. All it said was that he possessed a synthetic cannabinoid. And the mere possession of a synthetic cannabinoid is not a crime in this state. Only those particular ones that are contained in the public health law are the ones that are criminal.
So, counsel, to agree with you, would that devolve to a requirement that there always be a lab test?
As it is today, the answer is yes, Your Honor, unless the legislature recognizes that there is a problem. Many other states have made all synthetic cannabinoids illegal. This state has had multiple bills over the last several years trying to do that exact thing. That they have not done. And what's happening is, as Senator Ritchie points out, that it's essentially a whack-a-mole type situation. Every time they make something illegal, the chemists get around to subtly changing the chemical compound to make it a legal substance. Here only, as the Illinois court did in Katha, indicated only a person with an advanced chemistry degree would be able, through chemical testing, be able to determine whether or not a particular synthetic cannabinoid is an illegal one or a legal one. And that's what would be needed here. And it's not a particularly difficult thing here because these cases are generally prosecuted started with a desk appearance ticket. So before the client or the defendant comes to court, there is a period of time where this testing could take place. And if Senator Ritchie's bill becomes law, it'll be very easy because the request is to transform it from a misdemeanor into a felony. And then to have it at an indictment, there would be a chemist who would testify that the particular thing was a synthetic cannabinoid.
So what about an alternative? Would it be possible, I'm not speaking to this particular instrument, just as a general matter, would it be possible that the deponent, let's say the officer, could observe certain conduct that might provide indicia, perhaps unlawful actions that would allow for an inference of the possession of one of the illegal synthetic cannabinoids?
There is nothing that could possibly be.
Okay.
The bottom line is you can't tell. It is a liquid sprayed on dried vegetative matter.
And is the problem that there are those that are legal as opposed to illegal at the same time?
That is correct, Your Honor. And by charging him simply with possessing a synthetic cannabinoid, they have not made in this complaint that he possessed anything that was illegal.
Well, how about if they had said that he possessed an illegal synthetic cannabinoid and then referenced the public health law?
And if they had done that, there would still have to be evidentiary facts contained in the complaint that would indicate why they made that determination. It's no different than a situation involving pills. And not all pills are controlled substances.
Well, to get back to Judge Rivera's question, given the set of allegations that Judge Singh has just proposed, couldn't there be other indicia in where the defendant is, what the defendant's engaged in, that would further suggest that this was one of the illegal cannabinoids as opposed to the hundreds of
All of the synthetic cannabinoids have an effect upon the cannabinoid receptors in the brain. There are those that are legal that have that effect. There are those that are illegal. Seeing someone smoking something, and we don't even have that allegation here. Seeing someone smoking that substance does not indicate that what he is smoking is illegal.
You're really saying that, sorry, over here, that there's no way the defendant even could know whether what he was smoking was legal or illegal?
That's absolutely true, Your Honor. That was one of the other arguments that we had. How could he knowingly possess an illegal synthetic cannabinoid when he cannot tell it? No human. My wife is a retired chemist and pharmaceutical executive. She can't tell by her naked eye and naked nose whether something is an illegal or a legal synthetic cannabinoid. Only a chemist doing tests can make that determination. And the court in Illinois made that same determination. That's what's needed here. Or the legislature needs to fix it. The legislature has had this before it on multiple occasions. If you read Senator Ritchie's comments in introducing the current iteration of the bill, she recognizes exactly the problems that are involved with this particular type of controlled substance and why it needs to be made into a general form. The legislature has the ability to fix it. They've chosen not to. My adversary is relying primarily on cases involving cocaine, heroin, and marijuana, and say those cases control this. The significant difference there is all forms of cocaine, all forms of heroin, and all forms of marijuana at the time Kalin came down were illegal. Therefore, an officer would be able to identify those substances.
Counsel, I'm sorry.
Yes, sir.
I take that point, but this was a complaint, right?
Absolutely.
And there was a plea entered, and so we're judging this accusatory instrument by the standard of a complaint. Is there any difference in this case or in another case, going to what my colleagues have been asking, where absent a lab report, judging the standard by one applied to a complaint, you could survive a jurisdictional challenge on a complaint?
No, Your Honor. And
So
that's
it doesn't matter.
It doesn't matter. And the reason being is they have not alleged a crime in this complaint.
But what if they did? What if they said it's one of the substances listed in the relevant statute?
Then they would have had to have identified which particular one it was and how they were, how that officer was able to determine it was which one of these 10. That is clearly not here in this particular case. All he says is there's a chemical odor. Your Honor, if he had potpourri in a plastic bag, that is dried vegetative matter that has a chemical odor. Based on how this is now, he could have been prosecuted as possessing synthetic cannabinoid by an officer saying, dried vegetative matter, plastic bag, chemical odor. That doesn't correlate to anything in the public health law. And that as a result here, this is a defective complaint, irrespective of the fact that it is...
But why isn't that all what could have gone to the jury if there wasn't a plea? All of that could be challenged.
It's
The basis,
jurisdictionally-
if indeed the opponent had said, it's the packaging, it's the conduct, it has some odor, based on my experience, I think this is a synthetic cannabinoid.
But again,
Unlawful under the public health law, excuse me.
but again, Your Honor, that's not what's here. Does not allege that it was illegal.
But I was asking you before, would it be possible to add something into the instrument that might be enough short of a lab report?
There is nothing that could possibly be put in besides a laboratory report because it is impossible for anyone looking at this substance, touching this substance, smelling this substance to say that this particular item is one of the 10 contained within the public health law. Thank you, Your Honors.
Thank you. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is ADA Josh Weiss from the Bronx District Attorney's Office. It's a privilege to be here with you today. As the appellate term correctly found, the core concerns underlying the facial sufficiency requirement were clearly met in this case. Defendant was adequately furnished with the facts and attendant circumstances of his crime to prepare a defense and invoke his protection against double jeopardy.
So how was it clear that the one he had was illegal based on the instrument?
Your Honor, it's important to note here that the officer did not rest his conclusion solely on the category that defendant possessed synthetic cannabinoids. Rather, he specified that the substance defendant possessed was K2. K2 is widely associated with unlawful synthetic cannabis. It is a common name and it is a street name for the drug. And the public health law expressly provides that an officer is permitted to rely on the common name to identify the drug.
So the common name without a descriptor as to its identity, just the name. All he has to do is assert K2 and that satisfies the requirements?
Well, no, Your Honor, that's not the only allegation here. It also includes the officer's physical description of the substance. He described it as a shredded dried plant substance, and also that it had a chemical odor.
And to
Further,
distinguish it from those that are legal, how does that do that?
well, Your Honor, at this point, there was no requirement at this juncture at the pleading stage for the people to conclusively foreclose all possibility that the substance the defendant possessed was not unlawful.
So you just cast a net and you figure out if it was illegal later?
Well, no, Your Honor, but properly training our focus on the core concerns of facial sufficiency. Is the complaint sufficient to provide the defendant notice? These charges satisfy that standard. This court has upheld complaints on allegations with less specificity.
Counselor, the sufficiency, though, goes to a charged crime, and I think what we're trying to get to is where in this factual recitation is there a charged crime if there is no reference to anything that's illegal? And your point about K2 is not in the schedule, so where on this complaint, on the face of it, in the four corners, is there a charged crime?
Well, Your Honor, we believe that the officer's use of the common name K2 to allude to the subset category of illegal synthetic cannabis is enough to charge a crime. So if I may illustrate this point, another example would be crack cocaine. A substance identified as crack cocaine can still serve as the res for a criminal possession charge, even though that term appears nowhere in the public health law.
Yeah, but again, as counsel mentioned, at that time, all of cocaine was illegal. So a police officer saying you possess cocaine is enough to sustain an attack on the sufficiency of the complaint. The same thing with heroin. But when you say synthetic cannabinoid, we don't know because some are illegal and others are legal.
That is true, Your Honor, and that's why the analysis, particularly under the reasonable cause standard, turns on the reasonableness of the conclusion the officer draws in light of the facts he's offering in support of it. So, again,
How could the officer know? I mean, if what Mr. Ferguson says is true, the officer has to have a little chem lab with him.
I'm sorry, Your Honor, I couldn't hear
The
you.
officer would need to have a chemistry lab with him to be able to know if it's one of the 20 or one of the other 380.
That's exactly right, Your Honor. And these are trained members of law enforcement who are relying on their experience in the field to draw certain conclusions. It certainly can't be expected that police officers are going to possess the acumen of a chemist or a science. So the officer is simply relying on observable facts, his training and experience to offer.
But counsel, if what the officers, I'm sorry, I'm on the screen. What the officer's relying on are the exact same characteristics of what is not illegal or what's lawful, avoiding the double negative, then how can that be enough, even with the low standard that applies?
Well, Your Honor, again, under the less demanding reasonable cause standard, it turns on reasonableness. It's no different than an officer who mistakes baking soda for cocaine or an unmarked pill for an opiate. It's at the facial sufficiency.
But the difference is those substances are illegal. Cocaine is all illegal, and if within the descriptors and training and experience and what they saw, they can allege that which is sufficient for a complaint without a lab. The problem here is you have that which is legal and illegal.
Well, put another way, counsel, is if the officer had reasonable basis for believing it was cocaine, even if it's baking soda, they have a reasonable cause to believe it's an illegal substance. Here, there's no basis for saying what they believe it to be is illegal, right? It's different. It's not like, oh, they mistook cocaine for baking soda. They just don't have enough of a basis for saying the substance itself is illegal.
Well, we would maintain that these allegations are sufficient to support the conclusion. In addition to the fact that the complaint also notes that the defendant discarded the bag at the site of the officer. So for pleading purposes, that fact would at least bolster the inference.
Well, but that goes back to my earlier question, that assumes the defendant has an idea of whether he's smoking something illegal or legal, which I'm not sure, all he wants to do is to get high, presumably. He doesn't really care if it's one of the illegal ones or legal. He doesn't even know which it is. All he knows is it works. So the fact that he discards it because he thinks he might be prosecuted doesn't really bear on whether it's one of the legal or one of the illegal.
Again, Your Honor, I readily acknowledge that this complaint does not negate the possibility that the substance was unlawful. And furthermore,
No, it's not the question of whether it negates it, it's whether the officer had any basis. You know, for cocaine, it's packaged a certain way typically, or you can taste it and it tastes different from baking soda. There are things that an officer can do based on training experience to distinguish cocaine from baking soda. But what we have heard, and what I don't think you've disputed, is that there's any way an officer in the field can distinguish between one of the illegal ones and one of the legal ones.
no, Your Honor, the officer could not conclusively identify the controlled substance, and we agree that chemical testing would be required for the people.
Conclusively, can even make any, a probabilistic judgment that it is more likely legal than illegal.
Well, Your Honor, I would note that the reasonable cause standard for facial sufficiency is equivalent to the reasonable cause standard for making an arrest. So to countenance the heightened pleading standard that my opponent is requesting would render these statutes unenforceable. There would simply be no way to make a street arrest for this offense, and it would be denying these statutes the intent, the effect intended by the legislature if we were subjected to a heightened
Yes,
pleading
but
standard.
that goes to your adversary's argument that there is not let me put it this way, a judicial cure for this problem. This has to be resolved by the legislature because some of this is lawful and some of it is not. And as it stands, again, you've not said otherwise, the defendant's position is there's no way to distinguish it absent a chemical test. And so that's the problem, and one that his argument is the judiciary cannot step in and resolve that. That requires legislative action.
Your Honor, I would just note that the only aspect of the defense that defendant would not be able to prepare at the pleading stage would be to challenge the soundness or the methodology or the underlying integrity of the scientific testing. But he would be able to pursue all other elements of his defense. It's only that one component that would still be outstanding. He could move to suppress. He could. This was a case that predated the discovery reform, so he could have made discovery demands of us. So again, it's important that the inquiry be cabined to the underlying concerns with facial sufficiency. Does this provide him notice of the charges to prepare a defense, and is it sufficiently specific so that he could invoke his protection against double jeopardy to avoid re-prosecution?
I'm not sure that the concerns are limited to that. I mean, if hypothetically it turned out that 90% of the stuff being smoked was in the legal category and 10% was in the illegal, and officers couldn't discriminate based on what they see and they just start arresting people, you're going to have 90% of the people improperly arrested, which is a concern beyond anything that has to do with what they might be able to prove at a trial. There are consequences to arrest. I mean, you want to arrest people for things that are illegal, and you don't want to arrest them for things that aren't. And some of this isn't.
Right, certainly. Again, I would just refer back to the officer's use of K2, which is a commonly accepted term for unlawful synthetic cannabis, just as crack cocaine is widely associated with regular cocaine. And there are in the definition of cocaine, there for example, a substance that's derived from decoconized cocoa plant is exempted from the definition of controlled substance. So a police officer could still reasonably believe that the white powdery substance he observes in a defendant's possession is still cocaine, even if that's subsequently proven to be a mistake.
Thank you, counsel.
Thank you, Your
Counsel,
Honors.
you're welcome. Counsel, your rebuttal?
Your Honor, to seize upon what Judge Singas had pointed out, the public health law not only denotes each of the synthetic cannabinoids that are illegal, it also provides a series of trade names to it. Notably absent, as Your Honor recognized, is K2. K2 is simply a street name. There are hundreds of street names for synthetic cannabinoids. None of them correlate to anything that's contained in the public health law. And as to Judge Rivera, as you indicated, yes, there is a fix here. The fix here is within the legislature. And Your Honor, Judge Garcia, as you wrote in People versus Hardy, even in a complaint, you still have to allege every element of the crime. Here, there is no allegation that what my client possessed was an illegal synthetic cannabinoid. As a result, they have not alleged that my client committed a crime. And as the last attorney who gets to speak before your summer recess, I want to wish all of you a wonderful and relaxing summer recess, and I hope to see you in the near future. Thank you, Your Honors. Have a great summer.